So it has been a really long afternoon. So thanks so much to all of you for staying with us. We really appreciate you for hanging in. Some excellent advice from my colleagues in the last several presentations. So I saw a lot of people taking notes, and that's awesome. So I thought I'd try to wrap it up with some cost-effective measures that I think employers can take can have an immediate impact. Some of those were already discussed by Lori, by Jason, some of the others, but let me kind of go through those if I can relatively quickly to kind of amplify a few of the points that were made and maybe add some additional thoughts to some of the comments that were made before. Let me just, before I get into that though, I do want to talk about the point that Lori made, which is so well taken about, trying to not sound like an infomercial for more work for lawyers versus trying to strike that balance between handling these personnel decisions on your own. We try to get it about the cost of attorney's fees. We try to be mindful. We have a really experienced group, I think a wonderful group here. And what we try to do for our clients is really synthesize, distill some of the, that myriad and that blizzard of laws that are out there and try to distill it into actionable items for our clients. Okay. What things can they do that are concrete steps that they can take to kind of improve the workplace, get ahead of these issues, and be in a position to respond when they happen. Okay, we also get it that a lot of you who are HR professionals in your official roles or in your unofficial roles where you're wearing 5 different hats are often placed in a very unenviable position. Okay, you've got different constituencies, people I've worked with, they've got, partners or executives who want one result, they've got employees clamoring for a different result. Some of the decision makers may not even be on the same page in terms of their energy for a particular decision. There's a public relations, there's an optics piece to this. There's a concern about what happens if a suit's filed or a threat. There may be a business deal that's percolating. Maybe a whole wide variety of issues that are around and atmospheric about what's going on. And I think what our group does particularly well is try to sort through all that and come up with a second set of eyes, a second set of ears, kind of take a holistic view at these decisions. And, I can't tell you how many times I've had situations where I've said to myself, gosh, I wish that client I had 20 minutes to speak to the client before they made that decision. Because we could have navigated a different path. Or we could have taken that path and we could have course corrected in a couple small ways and we could have had a different outcome. Or we could have offered severance. Or we could have delayed it to let them find another job. Or we could have given them the option of resigning. Okay. Or we could have let them work from home for a few weeks, not have them come into the office so that there's no trauma. So there's a lot of things that we've seen, through our collective experience. We compare notes internally. We pick up the phone to call one another. Have you seen this? Have you seen that? And sometimes put our heads together and often put our heads together to come up with a solution that works for the client. So I think there's a value to that. So just, we're available and we're trying to meet you where you are in a given situation, given the circumstances that you find yourself in. And that challenge has probably never been greater. These laws are being, unleashed by legislatures, maybe it's too strong a term, but they're coming fast and furious. It's hard for all of us who deal with all this on a regular basis to stay on top of it. It really is. It's a huge challenge. And as Jim said when he was talking about the FTC ban, a bunch of us were like, okay, this is going to get shot down. It's a question of when. But the decision, it waited and it waited, and of course waited and they waited, and then the deadline's coming up, and how do you advise your client? So there's a lot going on. But let me amplify a few of the points. Because I think a lot of what we do in this space is helping to control the narrative. Okay, when claims get filed, when demand letters get written, when lawsuits get filed, it's about storytelling. What I like to tell my clients is, look, we want to be on the right side of the angels as much as we can. We want to be able to say to a court, to the EOC, or to the opposing counsel, we did everything we could to prevent this circumstance, this harassment claim, this leave claim, this overtime claim, this fill in the blank claim. Okay, and once it happened, we took a series of steps to address it. Okay, so that's kind of the overarching foundation for a lot of these comments that are included in here. It comes from that premise. Okay, because really what we're talking about is competing narratives. Plaintiff's narrative, which is, the ugly employer who takes advantage of employees or mistreated somebody, Invariably, in my experience, employment claims are about lack of respect. And the legal theories that folks attach to them are simply like code hooks. Okay, but if you draw the through line between leave claims, discrimination claims, harassment claims, wage claims, what have you, it's in one way or another, I think it's about a lack of respect or a lack of meeting expectations. Okay, so to me, the remedy, or part of the remedy, is training, 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 baking it into your culture at every occasion that you can. And you'll see in the outline here, one thing I really want to emphasize: interview training, strategies for hiring candidates, handling leave and accommodation issues, evaluating employment determination decisions and adverse employment actions. All too often I see, unfortunately, either newer managers or younger managers or folks who are uncomfortable coming forward and asking for help because they don't want to seem foolish. Okay, they're embarrassed. I don't want to come to Julie. I don't want to come to so-and-so. I don't want to come to Jeff. I don't want to come to somebody and show that I don't know how to handle this personnel situation. Okay. And as a result, they'll make the decision on their own. But they haven't been trained how to do that. So they're going by their wits, going by the seat of the pants. Okay. And then when it becomes a problem, then the hand comes up. Okay. So a lot of this is promoting the culture of people coming forward. Okay. If that culture is people can be, be free to go ahead and acknowledge mistakes in an environment where those have been made, where the culture is one of training managers, it's going to provide a lot of security and confidence going forward. Okay, and it's also going to help prevent things from falling through the cracks. So many times, Mike and I see this, Nicole and I see this, the left hand doesn't know what the right's doing. Okay, many discrimination claims look at from the surface like they're horrible acts. But in many instances, there's a lack of communication. And if managers understood that from the get-go, and how what they do and don't do ties the hands of HR professionals and in turn lawyers, okay, they might be much more willing to put their hand up. So when I do manager training for clients, I say I have a very modest goal. If folks can feel comfortable putting their hand up and asking a question before it becomes a big problem, I'm really happy. Anything on top of that is icing on the cake. So that's kind of the foundation for these comments. So the training, if it's baked into that culture, and managers know that they're going to come forward, and they're going to get routine harassment training, how to deal with problem employees, giving hypotheticals, how to handle overtime requests, right? Our chances of reducing those claims, okay, go up significantly, okay? And if we do have a bad outcome, we're in a much better position to defend those claims for all the reasons that Jace mentioned, right? Because we've done everything we could to prevent it from happening in the first place. And then we have an alarm system, right, in place to investigate it and take responsive action. That's a really good place to be. If it's not usually not a question of if, but when these bad outcomes and unfortunate outcomes happen. Okay, it can be a game changer in whether or not a plaintiff's counsel pursues a case. It can be a game changer in the amount of the attorney's fees. It can be a game changer in taking damages and potential components of damages off the table entirely. It can be that significant. And it can also be a game changer in whether or not an employee is going to run to a plaintiff's lawyer in the first instance. Okay, because when I do these manager training workshops, what I suggest to you is all these companies get on the top best companies to work for in America and Montgomery County and what, they're great. It's awesome. But nobody, I don't believe for a nanosecond that they don't have issues and problems and they don't make mistakes. Because they do. The difference is, have they built up enough goodwill with their employees so when these events happen, these mistakes are made, these foot faults are made, they resolve them without claims and drama and losing people and bad ambassadors out on the street who are saying you should never go work for that employer. Because I do think you get frequent flyer points for trying to do the right thing. Okay, so let's get a little bit more granular. Job descriptions, hugely important. I can't tell you how many employment cases come back and can be traced back to job descriptions. Okay, so dust those off. They're a pain in the neck. It's hard work. They're important for ADA issues and accommodation issues. They're important, as Jay said, for characterization issues in terms of exempt, non-exempt, right? And they're really important in terms of meeting expectations, in terms of what people are doing in their job and managing their performance. Okay. I much prefer sort of looking at the job descriptions as a pie chart. Okay, you can put bullet points to the cows come home in a job description, and that's great. These are the essential functions. But when you're speaking to employees about what they're going to do, perhaps think about giving them a visual of a pie chart. We envision you spending 25% of your time in this area, 30% of your time doing this, and so forth, right? You may not be able to be perfect in that assessment, right? But you're going to be able to get a sense of whether your expectation of the position aligns with the candidates. Make sense? So many situations get out of alignment from the get-go because someone's read a job posting, a job description, and they think they're going to be doing 10% sales and 90% research, and they want to be doing just the opposite. And the job description doesn't differentiate in the bullet points between what's the emphasis of. Okay? So again, job descriptions are huge. Dust those off. And as far as the wage and hour exempt issues are concerned, Mike and I have done a fair amount of this work. You can bake in some of the regulations from the Fair Labor Standards Act into some of these job descriptions to try to safeguard them if there's ever a claim that you mischaracterize them. What do I mean by that? The administrative exemption is probably the most common exemption that finds its way into litigation. And there's a bunch of discretion and independent factors, as Jesse alluded to, and others that come into play about whether you can satisfy the administrative exemption. What about baking those discretion and independent judgment factors right into the job description? Okay, your job will include, okay, some of the language, obviously customized, to make those job characterizations and decisions defensible. Okay, so job descriptions are huge. Dust them off, update them. Do they still make sense? I can't tell you how many times I've had clients when they went through that exercise have been able to use that as a way to inform staffing decisions. Do we need to hire more people? It's a way to inform and keep overtime claims down, because you're realizing that people don't need to be doing certain things that they've been doing. Okay, you can reduce the number of hours that they work, you reduce the potential for overtime claims, and you don't have to worry as much about getting hit with a big lawsuit. Okay. Interview and reference questions, and I know I'm getting close on time because the food's getting rolled in here. I'm a huge believer that you can improve your batting average in terms of hiring. Okay, maybe I'm naive and I don't get it, but I subscribe to that theory. What do I mean by that? Success leaves clues. When I do this manager training workshops, I ask people, I go around the table, tell me the 10 qualities, okay, work qualities of the people that have been successful in your organization. Invariably, I get qualities that hint at emotional intelligence. They're passionate, they're curious, they got fire in the belly, they're good colleagues, they're creative, they're thoughtful. Okay, they take ownership, they take accountability. Invariably, when I ask them, not to name names, what are the characteristics, work-related characteristics of the people that didn't work with? Okay, and usually it's the polar opposite, right? They weren't accountable, they were selfish, they were high maintenance, they were know-it-alls, they weren't collaborative, they weren't curious, they didn't want to work outside their little domain, whatever it may be. And sometimes this exercise, as little as 5 minutes, can be really eye-opening. And then I challenge clients to go ahead and open their interview questions and elicit questions which ask about those characteristics. Give me an example of when you went above and beyond what you were asked to do to come up with a solution that proved to be successful. And I ask it of young lawyers. Somebody says, I did a paper out when I was 14 years old, and I figured out a new way to fill the papers. Okay. I've got somebody that's got some passion about what they're doing, or they're creative, or they're resourceful. My chances of having a good hire just went up. My chances of having a termination claim, or a wage and hour claim, or discrimination claim just went down. The passion for the position. On a scale of 1 to 10, how would you assess your passion or your interest for what you're doing? Okay, and I've had people say, I found my lot in life. I'm doing exactly what I want to be doing. And I've had people put their heads down, their chins down, and say it's like a 2. Okay, what are the chances if someone's got that low level energy for what they're doing that they're going to be successful at your company? Okay, I think they go down precipitously. So what I'm suggesting to you is there's a way to reimagine the hiring process and reimagine the job descriptions to improve your chances of successful hires. They're going to be aligned the qualities and characteristics and the energy that you're looking for and the work qualities for someone who's going to be successful. Okay. And if you can tap into that, and if you can improve those chances, a lot of the issues that we're talking about today either go away completely or they're certainly mitigated. Okay. Because if somebody's got a sense of self-awareness, okay, and they take ownership of issues, how much more receptive are they going to be when it comes to getting feedback that may not be the best? Okay. If they're not succeeding in their position and things are not working out, is that individual who's somewhat more self-aware going to be more or less likely to go run off and file a claim? Okay, so it's all connected in my view. EPLI coverage. We talked about that a little bit on the wage and hour stuff. It is hugely important, despite all the wonderful advice you got from Lori and Jim and Julie and Mike and Nicole and Jason, Jesse today. You know, it's a challenging landmine, bunch of landmines out there. So explore, you know, with your agents, with your brokers, you know, the EPLI issues, both holistically and comprehensively in terms of what you have, okay, both in terms of scope and amount. As Jason correctly indicated, some of these statutes are evil, right? And they have personal liability attached to them. Some of these statutes, like the wage and hour, the FLSA, there are very few defenses to liability. Okay, so is the coverage broad enough? Okay, you may get credits. I've had clients get premium reductions for doing training. Ask about it. Shop it. See what you can come up with. Get more than one opinion would be my advice. And run it by counsel to look at some of the exclusions. Jim's going to be able to spot and say, wow, is there an exclusion for WARN Act claims? Okay, is this policy capturing the wage transparency issues? I have no idea. Nicole, any idea whether these insurance policies cover wage transparency violations? You know, I have no idea. But an insurance agent or insurance broker should. Lastly, let me end by item number 15 on the list, which is constantly review strategies for retention. I can't tell you how many times I see clients that sort of wipe their brow when the hiring is done and move on to the next 17 things on their to-do list and don't give retention really a second thought. But I would argue that it really starts the second day. Okay, are we providing professional opportunities, career opportunities, growth opportunities, mentoring opportunities, okay, involvement opportunities, connection opportunities in terms of meeting the employees and the candidates in terms of what they're looking for their experience? Okay, how can we be creative about that? What are our competitors doing? Okay, do we have a list? I challenge clients to keep a list of the reasons why people left. Right? How many people really do that? Okay, great, awesome. Because again, that's going to leave clues. Somebody didn't like their assignment. Somebody didn't like their manager. Somebody was bored to tears, right? That's going to help inform your hiring. That's going to help inform your training. That's going to help inform your sales pitch and your elevator pitch in terms of how you're going to position yourself in the marketplace. So again, I think continuously thinking about ways to retain employees, even if they're not all successful. My strong sense is that you're going to get frequent flyer points for that because employees are going to know that you're trying. You're trying to provide a seminar. You're trying to provide a career opportunity. You're trying to provide mentoring. You're trying to provide a community activity. Okay? I have a client that goes ahead and they give somebody 2 hours a month to go ahead and do whatever they want to do for nonprofits or civic organizations. Time off, paid. Okay, and then check in with HR to make sure it's legit, right? But it communicates to the employee that they want to, so the company wants to support them in their community life and in their life outside the job. Okay, and what it does is it breeds loyalty and it breeds, I think, a sense of the employer trying to do the right thing. So a lot to digest. Here's the list here. We had some other wonderful comments as well. But I think the challenge is really to go back and schedule those times for the manager training, put them on the calendar, no excuses for not attending. Okay, and I think with modifying and looking at some of these documents, looking at the job descriptions, okay, looking at your leave policies, updating your handbooks as we talked about, looking at your AI policy, okay, training managers on accommodation issues. You can make really giant leaps, I think, in terms of both mitigating these problems and improving compliance.
Yeah.
I get to do lots of things back there. We have refreshments in the back. We'd love for you all to